Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, Chevron USA Incorporated versus Plaquemines Parish, decided April 17, 2026.
Justice Thomas wrote the majority opinion, joined by 6 colleagues. Justice Jackson agreed with the result but wrote separately, concurring in the judgment only. The outcome, unanimous on the judgment, with Justice Alito sitting this one out entirely.
The bottom line, Louisiana parishes sued Chevron over environmental damage tied to World War II oil production, and Chevron fought to move that lawsuit from Louisiana State Court into federal court. The Supreme Court sided with Chevron. Understanding why matters, because where a lawsuit proceeds can change everything about how it turns out.
Federal court versus state court, different rules, different judges, potentially very different outcomes.
Exactly, and we'll get into what that shift means in practice. But first,
Before going further, a quick reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
all right, here's what you need to know. So, set the scene for us. What actually happened here? Picture late 1941. Pearl Harbor just escalated the war. The United States entered World War II, and suddenly the military needed staggering amounts of aviation gasoline, Avgas, to power its combat aircraft. A super fuel, high octane, gave pilots more speed, more power, faster takeoffs. In June 1940, the U.S. military burned about 4,000 barrels of Avgas per day. By 1944, the height of U.S. involvement, that number exploded to 636,000 barrels per day.
A 150 times increase in 4 years. Staggering.
Staggering numbers. So President Roosevelt created the Petroleum Administration for War, the PAW, to run the entire American oil industry from top to bottom. Production, transportation, refining, all of it fell under PAW oversight. The PAW issued a directive that left zero room for interpretation. Forget economic considerations. Forget everything except getting out more and more 100-octane Avgas as quickly as you can.
They essentially nationalized the oil industry for the war effort.
Essentially. And the federal government, through something called the Defense Supplies Corporation, started contracting with dozens of refineries to produce Avgas. One of those refineries belonged to the Texas company, which, over decades, became Chevron.
So Chevron's predecessor signed a federal military contract.
Right. Under that contract, Chevron agreed to work, quote, day and night to quadruple its Avgas refining capacity at its Texas refinery. The government could direct Chevron to buy crude oil from other suppliers. The government could purchase all of Chevron's excess Avgas at any time, a total wartime partnership between a private oil company and the federal government.
And where does Louisiana come in?
Refining Avgas requires crude oil, and Chevron produced crude oil right there in Plaquemines Parish, Louisiana, 2 fields specifically, Delacroix Island and Delta Duck Club. Some of that Louisiana crude traveled to Chevron's own Texas refinery and turned into Avgas for the military. By 1942, Chevron refined 4,000 barrels of crude oil per day from those Louisiana fields alone. The PAW called the Delta Duck Club field a critical field essential to the war program because it produced a preferential type of crude, especially well-suited for Avgas refining.
So the oil fields and the refinery operated as pieces of the same wartime supply chain.
And to maximize production, Chevron used 3 specific techniques at those Louisiana fields: vertical drilling, which maximized crude oil output; canals instead of roads, which saved time, materials, and manpower; and earthen pits instead of steel tanks, because the PAW directed them to preserve steel for other wartime uses. Not arbitrary choices. The PAW literally required vertical drilling through its own federal regulations. The government pushed Chevron to produce more crude, faster, using those exact methods.
Right. Now, fast forward to 1978. Louisiana enacted a new coastal management law, the State and Local Coastal Resources Management Act. The law required permits for oil production in Louisiana's coastal zone starting in 1980, but it carved out an exemption. If you legally started your operation before 1980, no permit required.
And that exemption became the battleground.
In 2013, decades later, Plaquemines Parish and other Louisiana parishes filed 42 separate lawsuits against oil and gas companies. The parishes argued that some of those pre-1980 operations, including Chevron's World War II-era activities, commenced illegally, putting them outside the exemption. The parishes' expert report went after Chevron specifically. Vertical drilling? Illegal and damaging to marshlands. Earthen pits? Bad faith. Canals instead of roads? Should have built differently.
So the parishes targeted the exact wartime practices the federal government required.
The main tension right there.
How did this get to the Supreme Court?
Chevron invoked the federal officer removal statute, 28 U.S.C. section 1442 A.1, and tried to move the lawsuit out of Louisiana state court and into federal court. That statute lets a person acting under a federal officer remove a state lawsuit to federal court when the lawsuit relates to acts that person performed in connection with their federal duties.
So Chevron argued, we performed federal military work. This lawsuit targets conduct tied to that work, so federal court applies.
Right. The district court rejected that argument and remanded, sent the case back to state court. The Fifth Circuit affirmed. The Fifth Circuit accepted that Chevron acted under federal officers as a military contractor. No dispute there. But the Fifth Circuit concluded the lawsuit didn't relate to Chevron's federal duties because the refining contract never specified how Chevron should obtain or produce crude oil. Silence in the contract meant no connection. Chevron then asked the full Fifth Circuit to reconsider, and the court denied that request by a 7-6 vote.
7-6. That's about as close as it gets. When 13 federal appellate judges split that evenly on a legal question, the Supreme Court takes notice. And it did, granting cert and stepping in to resolve it.
And one judge on the original panel had already pushed back.
Judge Oldham dissented from the panel decision. He argued crude oil stands as indispensable to Avgas. You literally cannot refine Avgas without it. So the connection couldn't just disappear because the contract stayed silent on production methods.
So what exactly did the court need to answer?
The federal officer removal statute authorizes removal when a lawsuit stands for or relating to an act performed under color of federal office. No party disputed that Chevron acted under federal officers when it refined Avgas. The only question, did this lawsuit, which challenged Chevron's crude oil production, relate to that refining?
And relating to can mean a lot of different things depending on how you read it.
Two little words, or relating to, potentially worth billions in avoided liability. Congress added that phrase in 2011, and the court's reading of those words determined everything. The court pointed to dictionary definitions. To relate to something means to stand in some relation to it, to pertain to it, to connect with it. Broad, but not unlimited.
A floor definitely exists somewhere.
Justice Thomas put it precisely. You need a connection that avoids the tenuous, remote, or peripheral, and he used two memorable examples. First, would you call yourself related to Joe just because you and Joe both trace ancestry to Adam and Eve?
Technically true in some cosmic sense, but no ordinary person reads it that way. Second, does a butterfly flapping its wings in Brazil relate to a tornado in Texas the following week? Thomas cited Edward Lorenz, the scientist who formulated the butterfly effect, to make the point that some attenuated causal chain exists, but we don't talk about weather and butterfly wings as related in any ordinary sense.
So relating to means something real and close, not just theoretically connected through a long chain of events.
Right. And Chevron's situation fits that standard comfortably. Much of the crude oil from the Delta Duck Club field fed into Chevron's own Avgas refinery. The practices the parish challenged, vertical drilling, earthen pits, canals, directly enabled more crude oil production, which directly fueled more Avgas refining. The PAW required or encouraged those exact methods. Pull them away, produce less crude oil, and Chevron's Avgas output for the military likely suffered. The majority called the context all hands on deck. Chevron needed to produce more crude as fast as possible to keep the Avgas flowing.
The crude oil production and the Avgas refining aren't separate things. They're the same wartime operation viewed from different angles. That's the thrust of the majority's view. And the court pushed back on the Fifth Circuit on two specific points. First, the Fifth Circuit said Chevron's refining contract never directed how Chevron should produce crude oil, so no connection. The court rejected that as too narrow. The statute doesn't require your federal contract to specifically invite the challenged conduct. Think of it this way. If your job requires you to show up every morning, your employer need not specify whether you drive or take the subway. Your commute still relates to your employment.
The contract doesn't need to spell out every step in the chain. The court drew on Ingersoll Rand versus McClendon, a 1990 decision, which held that a state law can relate to employee benefit plans, even when lawmakers never designed that law specifically to affect those plans. The relationship just needs to exist. Second point, the Fifth Circuit reasoned that the PAW's role in allocating crude oil among refineries cut off the connection between Chevron producing the oil and Chevron refining it. An intermediary severed the chain, the Fifth Circuit argued. The court rejected that too, through Morales versus Transworld Airlines, a 1992 decision, where the court held that state advertising rules related to airline ticket prices, even though advertising only affects prices through the independent decisions of consumers. An intermediary in the chain doesn't snap the relationship. The PAW, acting as a middleman, doesn't sever Chevron's production from Chevron's refining.
So, Justice Thomas and 6 colleagues held Chevron satisfied the relating to requirement, and the court vacated the Fifth Circuit.
Vacated and remanded for further proceedings. And that result? Unanimous on the judgment. Every participating justice agreed Chevron wins on this question.
But Justice Jackson didn't fully join the majority's reasoning, and that divergence carries real significance. The majority interpreted relating to based on its ordinary meaning alone and concluded that Congress's 2011 edition of the phrase loosened the prior standard, replacing a direct causal link requirement with something looser. Jackson pushed back hard on that reading. Where exactly do they part ways?
Jackson argued the court should determine what Congress actually intended when it added or relating to in 2011, rather than reading the phrase in isolation. And the legislative history delivered a clear answer. The 2011 amendment addressed a narrow, specific problem. Courts couldn't agree on whether federal officers could remove pre-suit discovery proceedings. Subpoenas or depositions served before a formal lawsuit even begins. Congress added or relating to specifically to clarify that those proceedings fell within the removal statute. The legislative record explicitly described the change as a conforming amendment, housekeeping, and stated that the bill made no changes to the underlying removal standard.
So the majority reads a housekeeping fix as a major substantive overhaul.
She cited INS versus Stevick, a 1984 decision, and Cyan versus Beaver County Employees Retirement Fund, 2018, both for the rule that Congress rarely changes substantive law through conforming amendments. And she leaned on Director of Revenue of Missouri versus CoBank ACB, 2001, for the idea that reading a radical but entirely implicit change into a minor cleanup amendment would be passing strange.
But she still agreed Chevron wins, even under her stricter test, which requires the federal duties to stand as a but-for cause of the challenged conduct. Chevron still prevails. Chevron produced crude oil, at least in part, to meet the demands of its federal Avgas contract. The contract caused the production. Causal nexus satisfied. She concurred in the judgment, not the reasoning. All right, what this actually means. So what actually changes after this decision?
For oil and gas companies, and really any company that performed federal government work during wartime or national emergencies, this ruling hands them a stronger tool to pull state court lawsuits into federal court. Before, you needed a tight, contract-specific connection. Now, a close relationship between your challenged conduct and your federal duties does the trick, even if your contract never mentioned that specific conduct.
And the stakes aren't theoretical. A Louisiana jury already delivered a $744.6 million verdict in a parallel case involving the same type of wartime activities, nearly $750 million, for 80-year-old oil production methods that helped fuel the Allied war effort. That number tells you exactly what Chevron and similarly situated companies faced in state court, and exactly why the forum question matters.
That verdict changes how you read this entire case. The difference between state court and federal court, for these companies, could mean the difference between survival and a company-ending judgment.
And that forum shift carries real procedural consequences beyond just the dollar exposure. Different rules, different judges, different defenses available, things that can look very different depending on which courthouse you walk into.
The court left important questions open. It didn't decide whether the other defendants in those 42 related Louisiana lawsuits satisfy the same relating to requirement. That litigation continues. The court also only addressed this one prong of the removal test. It didn't resolve whether Chevron satisfies the other removal requirements.
And Jackson's concurrence signals potential turbulence ahead, a future case with thinner facts where the private conduct and the federal duties connect less directly could produce a different alignment on the court. Jackson's causal nexus test would exclude some defendants that the majority standard might include. Future litigants will test those edges aggressively.
Bottom line, if your company performed federal government work, the conduct surrounding that work might earn a federal forum, even if your contract never mentioned it.
And in litigation, the forum sometimes determines the outcome, pretty significant for a decision that changed no constitutional right, altered no substantive law, and simply shifted the courtroom.
Sometimes the procedural stuff carries more weight than the headlines suggest.
Couldn't agree more. All right.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. Talk to you soon.